report to the House that on 27th June 2024, I received a memorandum from His Excellency the President referring the Finance Bill, National Assembly Bill number 30 of 2024 back to the House for reconsideration in accordance with the provisions of Article 115 of the Constitution. Honorable members, in the memorandum, His Excellency the President expressed reservations on the contents of the bill in its entirety and recommended the deletion of all clauses of the bill. In making the recommendations, the President noted the widespread expression of dissatisfaction by the public on the contents of the bill. Therefore, the proposed deletion of all the provisions of the bill will accord with its general rejection by the public. Honorable members, Standing Order 42.2 provides that if a message is received from the President at a time when the House is not in session, the Speaker shall forthwith cause the message to be transmitted to every member and report the message to the House on the day the House next sits. Consequently, in keeping with the provisions of Standing Order 42.2, on 27th June 2024, I notified all members of the message from the President and referred the memorandum from the President to the Departmental Committee on Finance and National Planning for expeditious consideration. Honorable members, following the submission of the memorandum, my office received several inquiries from members of Parliament and the general public regarding the fate of the bill and the manner of bringing the fiscal deficit arising from its rejection. Various misleading opinions have also been advanced on the fate of the bill following its referral back to the House. Given the gravity and import of the matter, I issued an explainer with a view to creating clarity and understanding on both procedural and legal tenets relating to the referral. Honorable members, one of the primary concerns then was on whether the President can propose the deletion of all operative clauses in a bill or indeed the entire bill. From the onset, I wish to clarify that the President's memorandum recommending rejection of the entire bill, though significant, was neither exceptional in our legislative history nor new to this august House. Members may recall that on 2nd May 2024, I conveyed a message from the President relating to the referral of the Penal Code Amendment Bill, National Assembly Bill, number 56 of 2022 back to the House for reconsideration. In the memorandum, the President expressed reservation on Clause 2 of the bill, which was the operative provision in the bill, and further recommended its deletion. This essentially constituted a rejection of the whole bill. Similarly, in the 11th and 12th Parliaments, the then President referred the Central Bank Amendment Bill, National Assembly Bill number 28 of 2014, and the Law of Contract Amendment Bill, National Assembly Bill number 1 of 2019, back to the National Assembly for reconsideration. In both instances, the recommendation from the President was the deletion of the operative clauses of the bills, which in essence constituted rejection of the said bills. Honorable members, a strict reading of Article 115 of the Constitution shows that no limitation is imposed on the nature of reservations or indeed the recommendations that the President ought to make on a bill. Indeed, this is also reflected in the practice in other comparative jurisdictions. For instance, in the U.S. Congress, the President, while referring a bill back to the House, may either choose to provide general recommendations based on the reservations to the bill or propose the actual text to be added or deleted from the specified parts of the bill. Honorable members, concerns were also raised on whether the Finance Bill 2024, having been referred back to the National Assembly, would become law due to affliction of time on the basis of the provisions of Article 115 of the Constitution. For clarity, Article 115 of 6 of the Constitution states, and I quote, 115.6, if the President does not assent to a bill or refer it back within the period prescribed in Clause 1, the bill shall be taken to have been assented to on the expiry of that period. For context, Article 115.1 of the Constitution provides that within 14 days after receipt of a bill, the President shall A, assent to the bill, B, refer the bill back to Parliament for reconsideration by Parliament, noting any reservations that the President has concerning the bill. A clear reading of these provisions reveals that the 14-day period applies to the President's action regarding assent or refusal to assent to a bill. As soon as any of the actions contemplated under Article 115.1 is undertaken by the President within the timelines prescribed, the application of Article 115.6 ceases to apply. In this regard, I wish to reiterate that the Constitution ought not to be construed in a narrow or sophistic sense. The Constitution should be interpreted broadly and liberally in accordance with the guiding principles provided under Article 259.1 of the Constitution. Bearing this in mind, it becomes evident that the 14-day period specified in Article 115 is a timeline for the President's action and not a date when the bill automatically becomes law. Therefore, the concerns alluding to the possibility of the Finance Bill 2024 becoming law due to affliction of time were and still are unfounded and a miscomprehension of the provisions of the Constitution. This also explains why the House was not recalled from recess for special sittings. Honorable members, now that the regular sittings of the House have resumed, I wish to state that Standing Order 154.2 requires the House to consider the President's reservations within 21 days when the House next meets. Under normal circumstances, the House would have had 21 days from today within which to consider and dispense with the memorandum. However, noting that the memorandum had already been referred to the Departmental Committee on Finance and National Planning for consideration on the 27th June 2024, I've been briefed that the committee is yet to conclude its consideration and shall table a report to the House on or before Tuesday, 30th July 2024, that is next week. Honorable members, permit me at this point to remind the House of the Speaker's communication of 28th July 2015 concerning the consideration of the President's reservations to a bill and amendments thereto.